you. Good afternoon. My name is Kristen Perkins. I'm with Rogers Towers, and I'm here on behalf of the appellant, Michelle Sasa, and I wish to reserve 5 minutes for rebuttal, please. May it please the court. The wife here in this dissolution of marriage case is appealing 3 issues from the magistrate's report and recommendation that was accepted in its entirety by Judge Carlin. The first is with regard to mortgage payments made on premarital property during the marriage using marital funds. The second is with regard to profits from the sale of the Queens building, a property that's also premarital. And the last is with regard to unequal distribution of tax liability with regard to a retirement account. As way of background, the parties were married on September 12, 2007, and the marriage lasted 4 years. The marriage brought the parties to Queens, New York, where the parties lived together in a premarital building that I'll refer to as the Queens building. During the marriage, the wife and the husband together made improvements to this property and helped manage this property, which included a rental unit and a commercial tenant. The parties lived in another rental unit within the building. During the marriage, the husband and the wife spent significant time clearing and cleaning a basement in the building, and they converted it to usable space. And the parties decreased the mortgage of this property by $23,651, which brings me to my first issue, which is with regard to these mortgage payments. These mortgage payments were made with marital funds during the marriage and should be subject to equitable distribution. Florida Statute 61.075 6A16 states, where there is an enhancement in value and appreciation of non-marital assets resulting either from the efforts of either party during the marriage or from the contribution to or expenditure thereof, marital funds or other forms of marital assets or both, such enhancement or appreciation shall constitute marital assets subject to equitable distribution.
Is there a difference between debt reduction and appreciation in value?
With regard to mortgage payments, no, Your Honor. These were expenses and expenditures made by the parties using marital funds during the marriage. And this equitable distribution of those marital funds is recognized by this court in Cornett, in Davis, and in Steiner. All cases from this district reflecting the law in this district that you should equitably distribute mortgage payments made with marital funds during the marriage if the property is premarital or non-marital. The appellee cites to Cole v. Roberts, which is a case from the 4th DCA. That case also supports the idea that mortgage payments made during the marriage with marital funds.
Well, was the argument here that the Cornett rule and the other rules that you mentioned somehow did not apply in this factual situation because the value of the property had declined during the term of the marriage? Is that what the argument was?
That's what the magistrate had accepted as the argument, that because of the Florida Supreme Court case of Ka, which the magistrate found that there was a depreciation in the overall amount or value of the property. It was purchased at $900,000 and sold at around $600,000 because of passive market depreciation, and that as a result, the mortgage payments that were actively made during the marriage should not be equitably distributed by the
If the mortgage payments hadn't been made from marital assets when the husband walked away, or well, he didn't walk away, he sold the property, he would have received $23,000 less, I guess.
That's exactly right, Your Honor. The property sold for $600,000. The parties paid off a mortgage of $300,000 and walked away with a $300,000 profit. The mortgage would have been $23,000 more that the parties would, or the profits, I guess, would have not reflected had they not made those actual payments during the marriage. And that's exactly why this district and the 4th District reflect the rule that mortgage payments made during the marriage should be equitably distributed. In addition, the Colby Roberts case that's cited by the appellee recognizes the idea that the distribution of mortgage payments that are made with marital funds should be independent of any contribution of labor toward the enhancement of the asset. So we're not requiring trial courts to go through and decide the extent of the value of a labor in order to determine whether or not these marital mortgage payments should be equitably distributed and what percentage. They are subject to equitable distribution pursuant to the case law and the statute. The second issue is with regard to the profits of the Queens building, which Your Honor had mentioned. So the Queens building was sold by the parties. The proceeds of that sale went to a joint account. The husband transferred most of the proceeds to a brokerage account solely in his name after the initial transfer to this joint account, and left some of the proceeds in the joint account to pay marital expenses.
So is the argument here that, for the wife, that by putting the proceeds or part of the proceeds into a joint account for a day or two, the husband made a gift to the wife of the proceeds of the sale of the property?
That's correct, Your Honor, with one distinction in that there was dispute as to how long the proceeds remained in this joint account. Some of the testimony was up to 4 days or 3 days. I think the magistrate found up to 3 days in the report and recommendation.
A relatively short period of time.
That's correct, Your Honor. However, the length of time that the proceeds were titled jointly isn't exactly an issue for this court or trial courts to decide. The court in Steiner v. Steiner, this court, 746 Southern 2nd, 1149, makes our job a little bit easier. Once this court stated, once the funds were deposited into a joint account, they lost their separate character and became untraceable. This joint account was used to pay marital funds.
Is that when they're commingled with other marital funds, though, or is?
In that case, I don't remember if that case the funds were commingled, but this joint account had other marital funds and expenses that were paid out of that account. So,
can the husband rebut the presumption of a gift?
Absolutely. It is an evidentiary rebuttable presumption. The husband testified in this one self-serving statement that he did not intend to make a gift of those funds. This similar testimony was also made in the Laws case, where the wife in that instance was attempting to rebut the presumption. Made a very similar self-serving statement.
Did the evidence also show that the money was not in this account for a very long period of time?
Yes,
correct?
That is correct, Your Honor.
And he pulled the money out at a time when the parties were, I don't know if they were separated, but they appeared to be about to go their separate ways.
That's correct, Your Honor. That both of those areas of testimony were fleshed out, but in addition, the husband paid marital expenses, paid an entire marital credit card out of the proceeds of the funds, of the profits, left money in that account to continue to pay additional marital expenses, and did in fact continue to pay marital expenses. The trial court and the magistrate never found that the husband met the rebuttable presumption outlining those facts that you had mentioned. The trial court simply reflected back the one sentence testimony that said that the husband didn't intend to make a gift, which Laws tells us isn't enough. That one self-serving statement isn't enough to rebut the presumption. And were the trial court to make specific findings of fact regarding any of those evidentiary or testimony or others, then we might have more information to go on. But right now, the report and recommendation completely adopted by Judge Carlin reflects the one statement by the husband that he didn't intend the presumption, or that he didn't intend a gift. So the last issue that I have is with regard to the tax liability.
As I understand it, the argument here is that the trial court assigned to the husband his non-marital Roth IRA, which had come from a 401k that he had while he was working before the marriage, and that I guess when he left his employment, he must have turned it into a conventional IRA, and then at some point in 2010 or 2011, it was converted to a Roth IRA, so that he got that as his separate non-marital account, and the trial court assigned a marital tax liability to the husband. So in effect, he's getting the benefit of the Roth account, because when the money comes out, he's not going to pay taxes on it, but the wife is really paying half of the assessment by the IRS and the New York taxing authorities. Is that it?
That is. Yeah, I'll add just a few facts to what Your Honor has said. First of all, in 2009, the Roth IRA was created by the parties, using in part a rollover IRA from the husband's employment and marital funds. This testimony was in the record. So this now Roth IRA, Roth IRA was created from this traditional IRA, including the rollover funds and some marital assets from the joint account. The contributions to the 2009, 2010, 2011 Roth IRA were the maximum contributions made using the joint checking account as testified by the wife. The only other part that I'll add to Your Honor is that the IRS in 2011 sent the wife a letter indicating that she's also jointly responsible for this tax liability. So the IRS
they filed a joint tax return, so they're both responsible.
That's correct, Your Honor. And so instead
This is my question. This is what I hope you can help me with. In looking at the equitable distribution worksheet, it appeared that the wife also had, I don't know if they're one or two, but she had, I think there were 2 Roth IRAs. Is that correct?
That's correct.
And they were assigned to her. And had they also been converted at or about this time?
I don't know. I know that her testimony was that in 2009, they both created a Roth IRA in his name and in her name, and that they both contributed the maximum using the joint checking account for those years, 2009, 10, 11.
So I guess what I'm trying to get to is this tax liability that they had from the feds and from New York State, was that attributable to the conversion of just the husband's account, or was it attributable to the conversion of her accounts as well?
The testimony with regard to the tax liability was specific to the husband's Roth IRA. There was no testimony that there was tax liability with regard to the wife's separate Roth IRA.
Well, if they were converted at the same time and they didn't pay tax on them,
well,
I'm not sure how that could be.
Because I don't think that there's testimony in the record that hers is a conversion. His was a traditional IRA that was converted to a Roth IRA. Monies were taken out without tax liability at that time to purchase real estate, and there was testimony in the record that there was no tax liability with regard to that large, I think it was $140,000 distribution, but that at this point they're facing the tax liability, and all the record evidence was
where could I look in the record to satisfy myself that the wife's Roth IRAs were pre-existing and weren't converted at the same time? Because I mean, if they were all converted at the same time, then it would seem like they both contributed to the tax obligation, and I'm not sure there's any evidence in the record that would allow you to separate out how much was attributable to the conversion of the husband's IRA and the conversion of the wife's IRAs, if in fact they were converted then.
Your Honor, when I come back for rebuttal, I will answer that question for you, but I will say I don't believe that there is record evidence with regard to that, and I certainly know that the magistrate did not make specific findings, which really is required, particularly for appellate purposes.
But I mean, if you're asking
these.
us to fix this because the husband has been treated the wife has been treated unfairly with regard to this tax liability, how do we do that if we don't know to whom the liability should be assigned and in what amounts?
Well, what I'm saying is I will only point to record evidence with regard to the fact that the conversion and the tax liability is specific to the husband's Roth IRA. That's in the record.
You have 5 minutes remaining.
Okay. I don't believe that there is testimony during any of the days of the trial with regard to any tax liability with the wife. So I'm not sure if you'll accept that kind of converse
I'll ask opposing
evidence.
counsel about it as well. So.
Okay.
And if you find something that's helpful, maybe you can enlighten us
will.
on the rebuttal.
Okay. Thank you so much.
Calvo. I represent Robert Samaska, the husband petitioner in this case, and appellee. Your Honors, we are asking the court to uphold Judge Carlin's final judgment adopting the report and the recommendations that were entered in this case. We feel that the magistrate carefully listened to the 3 days of trial, that she presented an equitable distribution that represented the testimony.
Why isn't the wife entitled to a credit for 1/2 of the pay down on the mortgage on the Queen's property?
Because there was no enhancement or appreciation. Your Honor, the evidence and the testimony presented to the trial court was that the premarital building located in Queens, New York, it was purchased by the husband about 10 years prior to the marriage. He valued that building in 2007 when they got married at $900,000. They sold it for he sold it for $680,000 in 2012. So it was a loss to him of $220,000.
It's undisputed that the mortgage on the property was paid down during the term of the marriage from marital funds to the extent of $23,000 and change.
Correct.
And the statute tells us, and the case law tells us, that if there's an enhancement in the value of non-marital property through marital funds, that's a marital asset that's subject to equitable distribution.
Right. And I think the question is really in how you define and how do you look at enhancement and appreciation and equity. And the definition...
is it possible that enhancement and appreciation are two different things here?
Well, I would see them as the same thing, essentially. We're looking at the increase in value. I see enhancement and appreciation as an increase in value.
But, I mean, surely you'd agree that if the mortgage hadn't been paid down with the marital funds, when the husband sold the property, he would, his check would be $23,000 lighter.
Perhaps. He also may not have sold the house at all. He actually testified at trial that the reason they sold the property was because the wife, who he had helped her obtain her child from the father, she wanted to move to Florida. And so that was the reason that he sold the property for the amount that he did at the time. He actually testified during the trial that he thought the value would be higher, but they had to hurry and sell it because she wanted to move to Florida. So it was a lot of decisions made by the wife during the marriage.
Is that a reason the statute doesn't apply and the case law doesn't apply, that they had some reason to move?
Well, Your Honor, I think the difference in the cases that are cited, Cornett, Davis, Steiner, and Cole, I think that the difference in those cases as to where we are right now is that those cases were all decided when there was still special equity considered by the courts. And so in those decisions, you'll see discussion about certain monies that were paid down for the down payment or certain monies that were paid on the mortgage. And when they were remanded to the trial court level, the trial courts were instructed to consider those as special equity. We don't have special equity anymore. We simply have the statute that says that the court has to consider the enhancement in value from either party to the marriage, whether it's with marital labor or whether it's with marital funds. And our position is simply that this property did not enhance in value. that it decreased in value $220,000 during the marriage. So if the wife is to be entitled to a payback of a portion of the mortgage payments that were made during the marriage, then husband in his non-marital building that he owned prior to the marriage loses $220,000 plus the additional monies that he paid for the mortgage. She essentially gets paid for being married, and that was an argument that we presented to the trial court at the time. Your Honor, those cases also, I'd like to point out, are very distinguishable because in each of those cases, there's no discussion of a loss in the property. There's always a discussion of an enhancement in value. Those cases were all long-term marriages. A lot of times we were talking about properties that were purchased towards the beginning of the marriage, and a good portion of the mortgage was paid off during that time. And that's not what we had here. We had a 4-year marriage, and we had a loss, a huge loss, in the valuation of this property.
Can you enlighten us on the subject of the Roth IRA and
Yes, sir.
how that was handled?
Yes, Your Honor. The wife came into the marriage with absolutely no assets. She did not have an IRA. She did not have a 401k. She did not have any property. Her Roth IRA was established during the marriage, and that's it. It was created as a Roth IRA. So there was no conversion tax issues with regards to her Roth IRA. She also had established a Roth IRA for the benefit of her daughter, and that's the second Roth IRA that the court referred to as a Magistrate account, and there was about $17,000 in there.
So is it safe to assume, or is it not correct to say that to the extent that the IRS and the New York State taxing authorities assessed taxes against these folks, that it's all attributable to the conversion of his conventional IRA to a Roth IRA?
We made that assumption, Your Honor. There was no testimony directly to that in court. I did ask the wife's expert, Leslie Ellis, who's a CPA, the tax return, the amended tax return from the federal government stating the amount of unclaimed income matched the amount that was transferred in 2010 from his traditional IRA to the Roth IRA of $79,000 and some odd change. So because those two numbers were exactly the same, it was our position at the trial court level that that transfer is what incurred the tax liability. I asked Ms. Ellis about the transfers triggering tax liabilities, and she said transfers like that can trigger tax liabilities. She was not able to pinpoint exactly that this specific transfer caused this tax liability and directly correlate it. But I did also ask her about multiple other transfers. You have to understand that the wife was managing these accounts with husband's permission. She took money from his traditional IRAs and transferred them to the Roth IRA. She made transfers in 2009, 2010, 2011, and 2012. Thus far, it's only the transfer from 2010 that has triggered any additional tax liability. But it was my position at the trial court level that it is very likely that if it was that transfer that caused the liability, that these parties will be facing additional tax penalties to the tune of approximately $150,000 in transfers that weren't considered at the time that we were in court because it hadn't yet happened.
So do you want to address the wife's argument that it's not fair to give the husband the benefit of the Roth IRA without also requiring him to assume the tax liability that's attributable to it?
Well, my first argument would be that that argument was not presented to the trial court at all. There was no testimony or any evidence that was presented to the trial court by which they could discern that there was going to be tax liability.
Well, I think the wife raised that in an exception to the magistrate's report, because I guess her position at trial was that these were marital assets and they should be distributed equally, and then the magistrate
Correct.
wound up doing something different and said, no, it's a non-marital asset, it goes to the husband. So then when she filed her exceptions, she said, well, she made the argument that I just described.
Well, there was no actual testimony on that, Your Honor. That was simply her statement in the exceptions. So there was no evidence by which the court could ever have actually considered that. And I'm not saying it's not true. Honestly, I don't even know. I mean, if withdrawals from a Roth IRA are non-taxable, then it might have been something that the court should have considered. But the cases that I cited in my brief specifically say that those tax consequences should be presented to the court. And so it was wife's responsibility.
Well, I mean, that's fairly common knowledge, isn't it? That the reason for converting a conventional IRA to a Roth IRA is, you pay the taxes when you do it, and then when you get the money out of the Roth IRA, it comes out and you don't have to pay taxes. I mean, that's...
Well, wife didn't know that, and she fancied herself a bit of a day trader. I think that had she known that she was going to be incurring those tax liabilities, she may not have made them. She actually presented testimony at the trial court level that tried to point the finger at the accountant as to why she didn't know that there was going to be these tax liabilities on the transfer. And certainly Mr. Samaska didn't know them either. So I don't know that was her intent. And I think really the crux of my argument is that it wasn't presented to the trial court. I don't think that the magistrate should have been required to sit in the position of applying knowledge that wasn't given to her in any testimony. The testimony from the wife at the trial court level was that the entire IRA account should be subject to equitable distribution as well as the tax liability. She was asked multiple times and she directly said, yes, the tax liability.
Well, I understand that, but then the magistrate went and did something different that maybe came out of left field that people didn't take into account at trial. But it was raised in the exceptions.
She did what we asked at the trial court level, because what we were arguing was that the premarital amount, which was $132,000 in his IRA at the time of the marriage, that he should retain that, and that the amount above that we actually subjected to equitable distribution. It was only about $2,000 left after that. But our argument was that he should retain his non-marital portion, and then the rest of what had gone on during the marriage ended up becoming something else.
Okay, how about, what's your position on the deposit of the proceeds of the sale of the Queens building into the joint account?
Well, again, we are faced with the situation that this was not an argument that was made to the trial court level. There's a decision out of this court, Franklin v. Patterson-Franklin, where the court talks about making arguments on the appellate level that were not made at the trial court level. But my position on whether or not it was a gift is that it was placed into a joint account. The joint account was opened on April 16th. The money was transferred in on April the 18th. And it was transferred in a series of different transfers. I think one was $150,000, one was $25,000, and there were two $5,000 transfers. The testimony from my client was that those were all funds directly relating from the sale of the building. That, on April 19th, so one day later, my client transferred $151,000 and $25,000 into an account that was solely in his name. The two other funds that were left there were just left there. There was absolutely no marital bills that were paid prior to him taking it back out of the joint account. That same day, on April 19th, the day that he transferred it out, there were two marital bills that were paid out of the account. So my position is that there was no commingling, which was the argument that was made at the trial court level, and there certainly was no donative intent of a gift. Again, my client testified at trial that he did not intend to give her those funds, and then he acted in that manner by taking the money away from her. He also further testified that she told him, I know why you took the money out, you don't trust me. She had the opportunity to rebut that testimony, and she never did. during the trial court level.
And were they separated at that point, or?
No, they still resided together. According to the wife's testimony, they resided together for a few more weeks, although the marriage was absolutely in decline at that time. Your Honor, the other, I believe that the evidence showed at the trial court level, and I cited Greco in my brief about the elements that the court should consider as to whether or not something that was placed into joint names was a gift, and I think that the husband rebutted any kind of presumption that there was on that issue. It's also important to point out that the wife, neither at the trial court level nor at the appellate level, has ever quantified the amount that she believes she's entitled to. We all say that it's the proceeds from the sale of the Queen's building, but the money that was placed into joint names, as I just laid out, was actually less than the total amount that was actually earned from the Queen's building, because it was made in different transfers and at different times. So that very first day when the money was placed into a joint level, it was not the entire profit from the Queen's building. It was just a portion of that profit, which wife has never quantified. She has always taken the position that she expects half of every asset that exists and every asset that husband had prior to the marriage, and she believes that the efforts that she expended during the 4 years entitled her to that. She made that argument at the trial court level, and she has again made it here at the appellate court level. I just want to make sure that I went over everything. Your Honor, I think I addressed everything that I wanted to point out to Your Honors today, and we would hope that you would uphold the final judgment.
I'm not sure, Your Honor, if you still have the same concerns with regard to the tax liability, but Mr. Somaska did testify at the trial level with regard to the tax liability being specifically attributed, from his understanding, specifically attributed to his Roth IRA, pursuant to advice from his accountant. The question was, what's your understanding of why you had to pay them, which is the IRS, $22,000, and his testimony was, yes, I tried to contact my accountant in New York who did my taxes, but unfortunately he never returned the call. I would not be able to do it, so I went to an accountant in Cape Coral and I showed him the tax. That was taking some money out from your 401k and we're putting it in a place to which now you have to pay all the taxes. And so then he says, okay, so there was a transfer from the IRA, transfer, yeah, question to another IRA, and it was a taxable transfer. Answer, which was, yeah, it was Michelle's doing. Again, I didn't do it. And so
what page?
That page 78 and 79 of Mr. Somaska's direct examination. And what Mr. Somaska says is it was Michelle's doing, and what I think the magistrate was getting at in her report and recommendation was the tax liability should be split between Michelle Somaska and Robert Somaska, because Michelle took the responsibility of handling the IRAs and the trading, and so according to the magistrate, the return on her investment was, I think, less than the magistrate thought it should have been, and so as a result of her active participation in the trading, she should share in the responsibility of the tax liability. And as Your Honor stated, our position is share in the tax liability, but share also in the asset. Provide our client with an equitable distribution of the asset, or else it's inconsistent with the court's decision in Lorman that requires an analysis of both facets if you're going to do an unequal distribution of a marital asset, which is exactly what the magistrate did in this case. And the only other case that I would point this court to in support of the arguments with regard to the mortgage payments and with regard to the equitable distribution of the property is, again, the Steiner case, which facts are very similar to this case. In that case, there was premarital property that the parties used as rental property. The rental income from that property was deposited into a marital account. Although the property itself maintained its premarital status, The proceeds from the renting of that property became a marital asset subject to equitable distribution after it was deposited in a joint account. Respectfully, I would ask then that you would find reversible error with regard to those 3 issues below and submit the case back to the trial court pursuant to those 3 issues. Thank you very much for your time.
Thank you.
Good day.
It's our last case of the day. You'll have a safe journey back, and we'll be in recess.
Thank you.